Good afternoon, مساء الخير, depending on where you are in the world. Welcome to the session on international humanitarian law in the digital age of PDAF. We're going to be discussing accountability, reparations, and Gaza's connectivity with a lineup of distinguished speakers. First of all, to give a brief on the session that we will be getting into now, we'll be discussing about the very obvious and clear failure of international institutions to protect Palestinians amidst the genocide in Gaza. The session will explore how international humanitarian law, also known as the law of armed conflict, can still serve as a tool to confront atrocities, demand accountability, and work toward preventing future violations. We'll be in particular discussing the situation where a belligerent occupation and genocidal conducts are taking place. The discussion will analyze destruction of Gaza's telecommunications infrastructure through the lens of IHL, in addition to the role of big tech companies and other digital technologies in exacerbating the Israeli genocidal campaign. With us today are the three distinguished speakers which have been introduced by the MCs earlier. We'll have with us Dr. Mais Qandil, Associate Professor International Law at Rebro University. Dr. Qandil is Associate Professor International Law at Rebro University. She has extensive experience in international humanitarian law and the question of Palestine. Her research focuses on the question of Palestine and international law, the implications of new technologies on human rights in the cyberspace, in connection with cyber norms and cybersecurity. She holds a PhD in international humanitarian law with a focus on Palestine from the University of Freiburg, Switzerland. Also with us will be Dr. Luigi Daniel, Associate Professor International Law, University of Molise. Dr. Luigi teaches and researches international humanitarian law and international criminal law. He holds a joint PhD awarded by Nottingham Trent University and the University of Naples Frederico II. Also with us today is going to be Melina Ansari, the Middle East and North Africa researcher at Human Rights Watch. We had originally planned for Adam Kugel to be with us, the Middle East Deputy Director of the Middle East at Human Rights Watch. However, due to unforeseen circumstances, Melina will be joining us in Adam's stead. Of course, we are really happy to have you with us, Melina. Melina monitors and reports on human rights conditions and abuses in Palestine and Israel. Over the years, she has gained valuable experience working with leading Palestinian human rights organizations, analyzing systemic violations of Palestinian prisoners and children's rights. Melina is a trained lawyer. She holds an LLM, International and Human Rights. Let us begin the discussion for today. We're going to do a couple of rounds of questions to address the main areas. Of course, we're hoping to hear from the various expertise depending on your backgrounds. So first of all, let us discuss legal accountability and international humanitarian law. How can international humanitarian law, which IHL for short, how can it be a tool for justice amid widespread violations? We'll start with you, Dr. Mais Qandil. I want to ask you, what avenues exist under international humanitarian law for addressing the destruction of Gaza's telecommunications infrastructure, especially within the context of prolonged belligerent occupation? How do you interpret such acts under the law of state responsibility in terms of reparations? And how does the occupation framework shape our understanding of ongoing violations and the responsibilities of the occupying power? Dr. Qandil.
Thank you so much, Jalal, for the introduction. First of all, there are actually many issues to unpack here in connection to these questions. But before we start with the violations and responsibility questions, I would like to emphasize on the fact that Israel is the occupying power in Gaza and Palestine at large. And it has a set of obligations under the law of armed conflict, or IHL. As well as international human rights law. So it's really important to kind of set up the legal basis here. In terms of human rights law, which is applicable in Palestine, the occupying power should be guided in exercising obligations, not limited to the minimum that is defined by international humanitarian law, but also encompassing the complementary rights and privileges codified by human rights treaties, And from here, we talk about all of human rights, the right to access to information, and so on, in terms of the digital rights as such. For IHL, Israel is under the obligation to restore and ensure public order and safety of the Palestinians. And these are the occupied people, also the protected people under IHL. And I would like to emphasize on the fact that Israel has the obligation to provide for basic needs of the Palestinian people in the entire occupied Palestinian territory. It also has the obligation to facilitate humanitarian aid. It's strictly prohibited to force people or to forcibly transfer people. It has the obligation to respect private property, and the destruction of property is absolutely prohibited, exception with absolute military necessity. So these are the obligations. In terms of the conduct that we look at to establish violations before we establish responsibility, because responsibility comes from the obligation and the violation of that obligation. The military operations must be proportionate to military needs, strictly distinguish between military and civilian targets or objects, and in order to minimize the civilian harm. The destruction of Gaza telecommunication infrastructure can be regarded as attacks against civilian objects, which must not be attacked, even if we regard them as a dual use, both for civilian and military purposes. The mass destruction that does not distinguish between civilians and military and combatants cannot be legally justified according to the general rule of the law of armed conflict. And not only the destruction of the entire cyber infrastructure, it's also communication blackouts as well as internet shutdowns. For example, they are not deemed to be legal at any point because they rarely meet the proportionality test. They are directly affecting people's safety and well-being and putting them at risk. When they make it impossible to warn people against danger or to kind of call for vital services. And they also have severe consequences, and they can never really be justified. Communication disruptions are also likely to have indiscriminate adverse effects on civilians, rendering them illegal, and so thus to be considered as war crimes. It's important to note that these destruction can be by both cyber means and physical means as well. But we also look at their violent and harmful effect. So, for example, human rights organizations have stated that Israel is using destruction of cyber infrastructure and internet shutdowns as a weapon of war and military tactics, creating an air of impunity during armed conflicts, and provide cover for grave human rights abuses as a form of collective punishment. In the context of the Israeli belligerent occupation in Palestine, it's in fact, Israel has the obligation to ensure that cyber infrastructure and communication infrastructure in Palestine exists and functions, which would lead us to implementing the law of state responsibility in connection to your question, Jalal, which exists on the premise that states have obligations to. If they violate their obligations, they will have to provide for reparations for their wrongdoing. In the context of Gaza, this translates to the fact that Israel has violated the set of human rights and humanitarian law rules, and so thus it is obligated to provide for reparation. In terms of IHL violations, we refer to the International Criminal Court for criminal investigations, but also when it comes to other violations and human rights violations, and particularly for the implementation and ruling on the state responsibility, we refer to the International Court of Justice. kind of to rule on the reparation of the Palestinian victims. And this is what actually the International Court of Justice has already ruled on its advisory opinion on the legal consequences arising from policies and practices of Israel in the occupied Palestinian territory. That the presence of Israel in entire Palestine, Gaza, the West Bank, including East Jerusalem, is illegal, and it has the obligation to provide for reparation. What do we mean by reparation here? We mean that Israel must provide for damages caused by its internationally wrongful act to all natural and legal persons concerned. Reparation includes restitution, compensation, and satisfaction. And all of these terminologies, they really differ in terms of how we look at reparation. So restitution, for example, means that the Israel have to return the situation as it was before. That would lead me to the fact that Israel is the one who is responsible to rebuild basic and civilian infrastructure in Gaza, because Gaza is still considered to be under the belligerent occupation of Israel. And then if restitution as such is not possible in whole or in part, then there has to be a more or less of a monetary compensation to those who are affected, to the victims. And also there is satisfaction, which means that the state that has violated its obligations, it has to acknowledge the breach of international law. It has to express its regret or a formal apology. And I would also add to this, also the same law talks about the interest, which means that even if we are at this point that Israel is going to, there is a ruling and Israel is going to pay compensation, then it has to also, we have to calculate interests that are paid to the victims. So in to sum up in that regard, it's the law is there. It talks about reparation. It talks about the state responsibility. But then the question is the implementation and how we can go further in terms of going to venues to implement and actually to get a ruling and try to repair or compensate those who have been affected by these violations.
Thank you, Dr. Mais. That's actually really important context for people to understand restitution, the reparations as context. I think something that we had just learned from the studies that we're doing, especially on the destruction of the ICT sector in Gaza, in terms of monetary terms, the destruction has cost an operational level losses of over $736 million. That's almost three quarters of $1 billion. The damage to the ICT sector infrastructure reached $164 million, and we are only talking about ICT infrastructure. We're not talking about the wholesale destruction and annihilation. The annihilation, which is the big question, which is why this is going to be the next question I'm going to go into. Dr. Luigi, we want to look at this also from, beyond the legal aspect. How do we assess the systematic targeting, and deliberate destruction of civilian infrastructure, such as telecom networks, as part of a broader strategy of annihilation? Can these acts amount to war crimes or crimes against humanity under the Rome Statute? I think this is a question on many people's minds, and I'd like to hear your expertise.
Thank you so much, Jalal, for the question, which is a crucial one. And let me just express my most outraged solidarity to all the Palestinian colleagues involved in the organization and in discussion, because what we are witnessing since 19 months, it's absolutely intolerable. And all of you have been an example of steadfastness in working, so in exercising your social functions, not only in Palestine, but worldwide. As for your question, this was something that has been debated a lot in the scholarship, in particular in the first stage of the assault on Gaza. I can start from what I have seen. I have seen systematically before each of the heaviest rounds of indiscriminate bombardments, shutdown of communications by Israel. In many occasions, we have been fearing for the life of so many colleagues in Gaza because we couldn't hear from them. So this already, in my opinion, shows that there was an intent in segregating digitally and from the point of view of the communication networks Gaza at the points of maximum lethality of the annihilatory attacks on the Strip. And then, behind this intent, we have seen stage by stage, month by month, the systematic destruction of substantially all civilian infrastructure in Gaza. So, to start from an antithesis, I can cite, and those who are following can easily find this video of the International Committee of the Red Cross that is called Explosive Weapons in Populated Areas. This video shows very clearly how targeting communication networks can have an impact of exponential multiplication of the lethality of war, of the conduct of hostilities. Why? Because if you target telecommunications networks, there will be people that will be unable to call for aid. If you target communication network, the first aid workers will have extreme difficulties in coordinating their intervention. So substantially, you are cutting off not only those that have already been killed by the attacks, but also those that can be saved. And we have seen the data about the monstrous mass injuring of the Israeli attacks. Only the Office for the Coordination of Humanitarian Affairs counts more than 100,000 severely injured. But then we need to add to this the systematic targeting of water infrastructures, the systematic denial of entry of goods indispensable for the survival of the civilian population. So we can see that the targeting of communication networks is part of a wider strategy that, in my opinion, and now in the opinion of most of the scholarship, finally, after so many months of horrors, is part of an intention to depopulate the Strip, to target life in Gaza, to make it impossible in situ. So, what I want to underline is somehow how we are witnessing, probably for the first time in history, a misuse of the law of armed conflict to justify an exterminatory logic behind the conduct of hostilities. That is to say, a genocidal war. Because, when I talk about intent to depopulate, to make life impossible, this perfectly fit into the definition of genocide of both the Genocide Convention and the Rome Statute of the International Criminal Court. So, in a way, the most effective answer I can give to your question is that, taken per se, these individual attacks against civilian objects, they are indeed war crimes under the Rome Statute of the International Criminal Court. Under this treaty, even a single attack against a single civilian object intentionally is a war crime. However, when we put together the scale, the systematicity, making of these attacks regular patterns, committed as if they were routine conduct of hostilities, we see that their addition produces the destruction of the victim group, or as the ICJ jurisprudence says, at least of a substantial part of it. And this has already happened. So why I was mentioning a misuse of the law of armed conflict, basically to justify genocide? Because in the last 25 years at least, not only from Israeli military discourses, but even backed up by Western military discourses and Western laws of armed conflict scholars, there has been a relentless campaign of propaganda to twist the categories of the laws of war to fit the Israeli narratives. That is why many of us are saying that this genocide was foretold. If we just look at the 2014 bombardments in Gaza, I often quote colleagues, eminent colleagues who are now the chief editors of the international manuals on the application of the law of armed conflict to cyber warfare. They were commending the operations of the IDF as extremely accurate, connotated by impressive capabilities, increasing their collateral damage accuracy evaluations. Okay, they estimated that half of the victims were combatant. Then, third and impartial analysis came out, and more than 80% of the victims were civilians, or to be presumed civilians, because their status was unknown. And more than 500 were children. Okay. Still, it has been affirmed that these were extremely surgical and targeted operations. So, you know, one bombardment of Gaza after another in the last 15 years, there has been a narrative built to distort the law of armed conflict and presume that all Palestinian civilians are a sort of population of human shields, that whenever there is an indiscriminate bombardment, that's just collateral damage. So we are talking about emptying concept of the law of armed conflict, of their protecting meaning, putting them upside down, project a brutal racialization on Palestinian civilians so that the Western world can presume that whenever they are killed en masse, they must be presumed to be lawfully killed. This is not what the law of armed conflict is about. This is not what the drafters of IHL had in mind. Despite all the colonial footprints of this legal framework, this is a legal framework to protect civilians, to limit the destructiveness and the suffering caused by armed conflict. And one last point, and then I leave the space to the Human Rights Watch colleague. This is a complementary legal field to the Genocide Convention. The Genocide Convention is equally applicable in armed conflict to protect a group as a collective as much as IHL is applicable to protect civilians individually. So what cannot ever be inflicted to anyone in armed conflict is precisely what is prohibited by both these legal frameworks, which must be read in coordination. The threat that comes by Israel to the entire world is that the law of armed conflict is construed as an exception to the Genocide Convention, so that a future of exterminatory wars is promised to the international community.
Thank you so much, Luigi. That's I think this was a very important intervention to make. It's important to understand that it's not just illegal, it's, you know, illegal by all means, by all measures, through every framework that we can look into in every lens. So much of the deliberate targeting of civilian infrastructure and the destruction of telecommunications is, of course, connected to the bigger picture of the campaign of annihilation. I think that's an accurate word. Melina, first of all, happy to see you with us. Thank you for joining us last moment. I really appreciate your inputs, of course, and your expertise. You're also, you know, part of the Palestine Digital Rights Coalition, and we're always working closely on those issues. So based on your experience from your field investigations and documentation work that you've been conducting, how do you see civil society and other human rights organizations can support the investigations by the International Criminal Court on future cases of similar caliber on the digital era violations in Gaza? Do you foresee barriers that remain in accessing justice? What are those from your perspective? Thank you.
Thank you, Jalal, and it's really an honor and privilege to join the Palestine Digital Rights Forum. Thank you very much. And excuse me if I look at my notes way too much, it's because I came last minute and haven't memorized. But pretty much my intervention really echoes and complements my esteemed panelists before me, Dr. Luigi and Mais, very much complementary to talking about the application of international humanitarian law in the conduct of hostilities in the Gaza Strip. But before going into the question, it's really important to highlight, during times of conflict, civilians, journalists, first responders rely on the internet to document and share evidence of abuses and to provide life-saving assistance. And during times of political crises, protesters also leverage the internet to organize online and stand up for their rights offline. And yet, time and time again, what we have been witnessing in this 21st century is that parties to the conflict deliberately shut down or destroy telecommunication systems in ways that violate people's rights. And shutdowns draw headlines. They attract people to the violations and abuses, but more subtle and equally devastating techniques to manipulate the internet deserve attention too, where authorities possess an arsenal of tools ranging from blocking specific social media or messaging applications to throttling traffic to restricting live streaming. And this is something that we should really take into account, and how civil society can support investigations in these violations as well. Towards the end of this question, I'll give an example of modern day tools of warfare that Human Rights Watch looked into, and the application of IHL to these tools of war. Although governments dictate blackouts, internet blackouts, it's internet service providers that are the ones who implement these blackouts. And companies, and this is part of the barriers maybe that we witness and see, is that companies frequently justify compliance with shutdowns and other requests by governments as a matter of following local law, suggesting that they risk losing their license if they don't follow what the government's rules and policies are. But providers should not be only blindly following local law, they should be heeding and considering implementing the UN guiding principles on businesses and human rights, the most widely accepted set of rights with regards to standards of businesses, and these companies should be doing everything in their power to push back against requests that would make them complicit in human rights abuses. After all, the UN Human Rights Council has unequivocally condemned measures to intentionally prevent or disrupt access to or dissemination of misinformation online that is also in violation of international human rights law as well, not only humanitarian law. When answering, Jalal, your question directly about what are we documenting, how is our documentation helpful to ongoing investigations and barriers, really since the start of hostilities, the recent one, at least in the Gaza Strip, we looked into, the extensive reporting of the Israeli military's use of digital tools in their operations in the Gaza Strip, where the Israeli military is reportedly using surveillance technology, artificial intelligence, and other digital tools to help determine who and what to attack in the Gaza Strip and when. We looked into 4 digital tools that the Israeli military is looking, and found that all 4 digital tools or rely on faulty data and inexact approximations to inform military actions which risk Israeli forces violating international humanitarian law, in particular the laws of war concerning distinction between a military target and civilians, and as well as the principle to take all feasible precautions before an attack to minimize civilian harm. I'm basically talking about the tools like the gospel, where's daddy, lavender, that have emerged more recently, but have been used by Israeli forces for many years. And we know that digital tools on their own are not military weapons. However, their use in military operations subject them to the same restrictions of international humanitarian law that should apply to any weapons. As the International Committee for the Red Cross has noted in their commentaries, and I quote, any new technology of warfare must be used and must be capable of being used in compliance with existing rules of international humanitarian law. And our research indicates that the tools that the Israeli military has been relying on apparently are based on ongoing and systematic Israeli surveillance of all Palestinian residents of the Gaza Strip, including data collected prior to the current hostilities in a manner that is incompatible with international human rights law, where they're using Palestinians' personal data to inform military action, like threat of predictions and identification of targets. And this is extremely problematic because, in the history of cases of the ICC and the tribunals like the ICTY in Yugoslavia and the ICTR, we don't have precedents under international law that talk about these digital tools. So the role of civil society organizations and organizations that, for example, are capable of analyzing international humanitarian law and analyzing these digital tools is supportive of these investigations, is in a way complementary to the work and investigation of justice mechanisms like the ICJ and the ICC, and even the Commission of Inquiry in the question of the occupied Palestinian territories as well as Israel. So we serve as an infrastructure or as a basis to how we should analyze the use of these digital tools or the use of these new form of, let's say, violations of rights or warfare in order to, seek justice and accountability for the victims. So it's really important not to stop at not knowing what these tools are, but really understanding their implementation under international humanitarian law. And again, I emphasize it's the question of distinction and the question of precaution, using all precautionary measures available, which we have seen complete, inability of the Israeli forces to comply with these obligations, making it really a question of how will the ICC move with its investigations and seek true justice and accountability for all the situation that we have come to. Thank you.
Thank you so much, Melina. Those are all really interesting, interventions on a very critical issue. But, when we're looking at what Israel is doing, we're not only looking at one main actor who is facilitating crimes against humanity, war crimes at such a large scale. There is private corporations who have emerged as major players who have facilitated the crimes committed by the Israeli military in Gaza. And in this context, I know we are running short on time, so maybe I'll make this round of questions very quick because we have to focus on big tech companies and their role in the genocide. Maybe the speakers may dedicate a couple of minutes for the questions. Dr. Mais, if we start with you talking about technology and big tech and accountability in this domain, how do you see this intersection of digital rights and international humanitarian law in light of the tech facilitated warfare? Will international law be addressing the responsibilities to guarantee digital access, protecting communications infrastructure? Do you foresee this? I know we've addressed this question, but do you foresee this in the future, that there will be a bigger role in this digital tech facilitated warfare? Maybe you're muted, Mais.
Yes, I'm muted. Thank you so much, Jalal. Actually, my answer would echo my colleague at at Human Rights Watch, but it's also for the way we see digital rights. They are there, they are applicable, but also when in connection to warfare, the destruction or the warfare itself is basically violating human rights. And then we are talking about digital rights as such. And here we are talking about the right to access to the internet, access to information, right to freedom of speech, and so on, data protection. And here it's basically also kind of to emphasize on the point where Palestinians are being subject to mass surveillance and datification, where all their data is being collected without any restraints whatsoever. Even also based on not only on CCTV cameras in the streets and those which are even directed to the private homes of Palestinians, and especially in the cities of Hebron and Jerusalem. But it's also at the bigger level with the interception of communications, with also. Not even with the help of these tech companies, and then there we have all of these tech companies and social media platforms that are in fact aiding and abating and facilitating the conduct of genocide, because if we look at it, surveillance as such has been used as a tool for control and mass killing. And here we are back to these AI systems that have been used, that Israel is using, in fact, on Palestinians in Gaza, where, for example, I think back again to Human Rights Watch report, they basically estimated that Lavender system allows for the killing of up to 100 civilians. So these systems are not. It's not even that they are not accurate. They are designed to kill civilians. And the very premise of them is very much illegal. So when it comes to these tech companies, well, first of all, mass surveillance and datification of Palestinians cannot be even seen as a conduct that is justified by military necessity or any military operations, because it's indiscriminate. So it's both targets civilians as much as combatants. So when we are talking about these actions, they are not only violating the rules of IHL, but also they are violating the very basic human rights. So here I just want to I want to kind of go back to your question, Jalal, on how we can hold these tech companies accountable. I think I would go back to the Convention on the Prevention of Genocide, because everyone, including non-state actors, are to be held accountable for their participation of the conduct of genocide. It's not only the state actors, not only those complicit in it, not only those who are aiding and abetting, it's also the non-state actors, companies, including even individuals, if possible, to hold all of these actors accountable for the violation of a set of human rights, set of humanitarian law rules, and most importantly, the convention, the Genocide Convention.
Thank you so much, Dr. Mais Khandil. Dr. Luigi, if it's possible for you to tell us, is there, you talked about your colleagues and where they are now, which is not always, the most encouraging things to learn, but do you think a year, 1.8 years, a year and 8 months and 9 months of the genocide, is there a growing space within international law to recognize the role of digital platforms and infrastructure destruction as tools of warfare? Has there been progress? I've seen updates. I've seen a call for inputs from the International Criminal Court and other institutions. What innovations are needed to ensure protection in this new and digital era?
First, I very much agree with what Milena and Mais were saying, and I'll try to put all together in these 5 minutes. We need to understand what we are dealing with. Okay, and I try to bridge these with what I was saying in relation to the distortions of the laws of war. We are dealing with a machinery that goes far beyond Israel. Let me echo Dr. Ghassan Abu Sitta when he says this is the Western genocide, not Israeli genocide. Why? Because on the one hand, we had these earlier experimentations, right? Mass surveillance in the West Bank, leading case in history of occupation without boots on the ground in Gaza. Drones 24/7. We know about it already, and we had this experimentation of legal political dispositives to transform Palestinian civilians in a mass of collaterally exterminable people. Okay, this responded to the interest of the most brutal between the settler colonial forces ruling Israeli politics. But there is another set of interest that we need to identify, and is the set of interest behind what Milena and Mais were saying. This is the last frontier for Western surveillance capitalism, big techs and big data to evolve in their ultimate and most terrifying stage, which is profiteering by becoming a sort of infrastructure of a genocidal leviathan. When you have softwares called "Where is Daddy?" I mean, Milena was being kind and elegant in saying they risk to violate IHL. They are, in my opinion, structurally designed to dismantle legal boundaries. Where is Daddy is called in this way because it's the software that Israel has developed to target suspected members of Hamas and Palestinian armed groups when they go back home, which means with their kids, families, neighbors. Okay, so why I make often recourse to an old Marxist category, Marxists in the last century were saying the proletariat is the general class, because they meant that workers and their emancipation were those through which the entire society could emancipate and live better. Not only the workers, even their social allies, and meaning the vast majority of the people. Sadly, I think that Palestinians are today the general class of the global society, because if the experimentation of the extraction of profits from this genocidal leviathan is successful and unaccountable and unpunished and unsanctioned in Gaza, then it is ready to be exported everywhere. That's why when people chant in the demonstrations, "We are all Palestinians," I think they express more than just solidarity. They express an intuition that has a great profundity. Because tomorrow, in the wars of tomorrow, in the winds of great wars of the international community, we can all become subject to the same intolerable set of atrocities, making recourse to a digital infrastructure used for criminal purposes and the extraction of incredible profits from it. That's why I think there will be increasing space for accountability. One last point, very quick. There are no rules written precisely for cyber warfare or for application of AI. This means that the same rules of IHL that are being distorted to exterminate here might tomorrow be distorted to call us extensions of some terrorists connected to this very meeting, okay, so that we can all be either killed or spied through sophisticated spyware for the rest of our days. So that's why I think there is space, but I think we need to make space by pressure for this kind of accountability and legal reform.
Thank you so much, Luigi. Do you recognize we're nearing time? We have 10 minutes left. Melina, I want to be open-ended. I want to leave it open-ended in the final question. I want to ask you about, the role of tech companies. And I know that Human Rights Watch has done some decent work on identifying some of the tools, the digital tools employed by Israel to facilitate IHL violations at a large scale. But also there's been problems with how big tech companies have played a role in shaping the narratives, limiting access to information, and facilitating violations that we're talking about throughout this session. From your perspective in Human Rights Watch, of course, I'm very honored to be speaking to all three of you because every single one has a very strong case. But I want to hear what forms of accountability can we pursue from your perspective through your work that you're carrying out today? Please, Melina.
Thank you, Jalal. And bearing in mind the time limitation, really, I'm just going to say it loud and clear. I'm going to use the remaining of this time to name and shame a big tech company that is really or has been playing really an integral or complicit role in shaping the narratives during this time. So hopefully, I understand that this naming and shaming is an answer to what forms of accountability can we use, because we should not just bow down to big tech companies and let them do whatever they want. We should be loud and clear. And after giving the example of this tech company, I'll give another solution where Human Rights Watch, Hamle, and the European Legal Center, Counseling Center have also found ways to use accountability measures. And I'm basically talking about Meta. In December 2023, Human Rights Watch found that Meta has been silencing voices in support of Palestine and Palestinian human rights on Instagram and Facebook in a wave of heightened censorship that is systematic and global, failing to meet its human rights due diligence responsibilities. And we analyzed over 1,000 cases which revealed clear patterns of censorship. And we also analyzed Meta's policies and practices. We found that these patterns of removal, so removing content, are not isolated incidents, but were baked into Meta's system and how the company applies its policies. And we basically found huge flaws in Meta's content policy. Principally, it's dangerous organizations and individuals policy, which contains sweeping bans on vague categories of speech, and the inconsistent and opaque application of its policies that contribute to censorship. To say it in less formal words, we basically analyzed, for example, how many posts did Meta delete just because they had "from the river to the sea" in them, or "free Palestine," or that had the word genocide in them. And there were like thousands of cases where there was absolutely no risk or no dangerous organizations or individuals, like no actual, violations of the guidelines that Meta has on Instagram and Facebook. So this was extremely problematic in a time where Palestinian voices needed to be heard. It's been more than a year, I'd say, and more than a year and a half, where Palestinians have been using every means possible available to them to let the world hear them, to show the world what exactly is happening. And Israel has been doing exact opposite of trying to silence Palestinians in any way. But complicity and actions of silencing Palestinians does not stop at Israel. It stops at big tech companies, exactly like Meta, who refuse to allow Palestinians to speak up without the censorship. So how were we able to, hold Meta accountable? Or what avenues do we have for accountability? It's not only about reporting, but it's also using litigation. I know when we say International Court of Justice or International Criminal Court, it seems like something way big, like for senior war criminals or whatnot. But no, it's a place also for tech companies and media companies who can be and are in many times complicit in grave abuses that fall under the Rome Statute. But I mean, if us as organizations can go as as far as the ICC, there are legal revenues available in our national areas. In Europe, for example, a small example of how we use this, our report on Meta, is we use the complaints mechanism under the EU's Digital Surveillance Act for content censored by Meta. So we went back with Hamle, with ELSC, to people based in the EU who shared evidence with us to get their consent to participate in this project, where we gather in cases and then appeal before a European Court for Human Rights. And this is what each company or each organization and civil society organization can do, and in support with many organizations that are mandated to provide legal services and appeal cases like this. What I'm trying to say is, and from the beginning of the answer, it's naming and shaming. It's really now the time to speak up and stop bowing down to tech companies in a time where we know for a fact they are being run by individuals who are also complicit and has many concerning question marks around them. So sorry for being extremely brief, but very respectful of the time. It's using legal avenues, local courts, national courts, regional courts, and also using the complaints mechanism.
Thank you so much, Melina. Thank you, Luigi, and thank you, Mais. I cannot thank you enough. Of course, this is extensive. All your expertise are, eye-opening, especially in this really difficult, not hopeless situation we're in. It's a difficult situation, and that's why we're speaking today to, consolidate where our expertise are and what pathways and what avenues can still be utilized in this coming time. And as you say, Luigi, the laws still apply. The international frameworks still apply, and this is something that we have seen. It's a dramatic war against international human rights, international humanitarian law standards. It's a war, a genocide that's aimed at dismantling the frameworks that have, been at the base and the core of our humanity in modern history, at least. So this is something we understand. I don't believe there were questions from the audience. Perhaps maybe one question on Amnesty previously reporting on the use of surveillance tools like drones in the Gaza Strip, and how we can track how Israel uses this surveillance data and how they sift through it. One thing I want to mention is that, of course, this is part of the work that Hamle has been reporting on, and other colleagues have also reported on how Israel is using those systems. One thing we want to highlight is that not only is Israel developing systems to target people using masses of surveillance data that is illegally obtained, but also that Israel is assisted by major tech companies based abroad, and to name a few, Microsoft, Google, Amazon are the main ones which are proven to have a strong relationship in providing Israel with the tools that help them sift through the surveillance data to take action, which means targeting civilians in Gaza in an indiscriminate manner. I recognize that we are at time for this session. Hopefully this will be uploaded on Hamle's YouTube soon. We thank you all very much for your contributions, our speakers. It's excellent contributions, very informative, and I cannot wait to revisit the entire conversation. Thank you all so much. Thank you, Ibrahim, for directing.